Hi, everyone. Welcome back to the Legal Blend podcast. My name is Kaefer Garcia. I am your host. And today we have a very special guest that I want to introduce. But before we get to that, as you all know, I usually feature a local coffee house, coffee shop in the area. And for today, we are featuring Muse. They're located in Lyndhurst, New Jersey, right off of Stuyvesant Ave and on Valley Brook Avenue. And the good thing about Muse is that, first of all, when you walk in, the ambiance is amazing, great. People are sipping on their coffee, people are doing their work, there's enough space to sit around, but also their coffee, their specific flavors. Even, I believe they have hot chocolate, right, Stephanie?
Yeah,
And I know that you are a fan of Muse, correct?
that's correct. Yeah, it's
What I
definitely a neighborhood friendly cafe. They have a small selection of different coffees, lattes. It's very specific.
Gotcha. So that was even better than I described it. And now moving on to Stephanie. So we have Stephanie O'Neill. She is a partner here at Garcia Law, and she joined us about a year ago, actually.
Yeah.
And Stephanie has dedicated her past 9 years of practice of being a lawyer in the field of family law. So that includes divorce law, custody, parenting time issues, child support, relocation issues. So Stephanie deals with all those issues in the space of family law. She's actually a court certified mediator in the state of New Jersey, and she has been nominated to the Super Lawyers Rising Star section for the past several years. Am I right?
Yeah, that's correct.
Perfect, perfect. So, join us in welcoming Stephanie O'Neill to today's episode. And Stephanie, first thing I want to ask you, tell us a little bit about yourself. Who are you?
Yeah, so as you said, I've been practicing in New Jersey for the past 9 years, exclusively in family law. Um, as soon as I was barred, that's the area that I came into, and I stuck with it all this time, and kind of created a niche in that specific area.
So, where did you grow up?
I grew up in Queens, New York. I knew from a very young age that I wanted to be an attorney, helping people. I really wasn't sure what type of law I wanted to go into, but I knew I wanted to help people. Ended up going to Rutgers Law, graduated, and then I sort of just fell into this practice area of family law.
So, why family law? Why dedicate the past 9 years of being an attorney into family law? What calls you or draws you to that field?
Yeah, there wasn't ever really a specific reason. When I initially started law school, and even before that, I was very interested in like human trafficking law. And in many ways, the areas overlap. And so, when I was studying human trafficking, I kind of also started studying family law, took a course in law school. And then as the time came closer to graduation, looking for jobs, that's sort of the area that I gravitated towards. So I can't really say there was any specific reason. I knew that I wanted to go into private practice because I knew that would be the area, I knew that I would be able to help people in that way and, represent families, whether it was helping them in child custody cases, child support, divorces, and domestic violence. That's also another one where I knew I wanted to, um, go in and help however I can.
So, we're going to address a few what I call divorce myths. So, for the viewers out there, if you also follow our Instagram page for Garcia Law, periodically we post divorce myths. So, divorce myths, what we call divorce myths, are things that we see week in, week out during our consultations, things that always are asked, always are delved into in our consultations. And we thought it'd be great to post about it in the Instagram page, but also bring it into light today with Stephanie to see her take on it and discuss it a bit further. So the first one, Stephanie, I want to bring up is, let's say a client, or if we've heard clients, right, many times say, so my spouse cheated and therefore they're not entitled to alimony. What would you say to that?
Yeah, this one is a popular one. So that's not true. When it comes to infidelity, that really doesn't have much of an impact on the issue of alimony. It's a separate issue. It's a separate, what we call cause of action. New Jersey, for the most part, is a no-fault state divorce. So what that means is, the court really isn't going to go into the issues of why you were divorced. Specifically, if you're filing for irreconcilable differences, you're essentially telling the court that there were differences in the marriage and that's why you guys can no longer be together or be married. It would be different if you file under the cause of action of adultery. But even in those cases, it still has very little impact on the alimony issue because when the courts look at alimony, there are a set of different factors that they look at.
Bottom line is, if a spouse cheated, they did not cheat. Your take is it does not affect alimony whatsoever.
Correct.
You also mentioned alimony factors. So can you delve into just a few alimony factors in the state of New Jersey, and who considers these factors?
So if the parties were to go to trial, the court would have to consider several factors in order to determine whether alimony should be granted.
Okay.
Some of these factors include the income level of the parties, whether children are involved, the length of the marriage, that's an important one, whether, one party was out of work for part of the marriage or the duration of the marriage, and whether there's a disparity between the incomes of the parties.
If we're talking about alimony, we're talking about infidelity, would you say the majority of divorces that you've dealt with in the past 9 years are do I would say is the common theme irreconcilable differences, that they've had differences for a period of 6 months for our viewers so they know what that means, right? In the state of New Jersey, you can file after 6 months of having differences between each other. Or is it adultery or other causes of action? What would you say is the majority?
Mostly irreconcilable differences.
And why is that? Do you have an opinion on that?
Yes, I do. And I think that's because other causes of actions are harder to prove.
Now, the next myth that we and I laugh because this will shed light, I think, into how the court systems work, right? Because we see, we have the Law and Orders, the Suits on TV, right? All these shows that portray our profession in a glamorous way. And sometimes it's not that glamorous, or there's certain things that they do that we are not allowed to do, right? So the next one I want to bring up, a divorce myth, is we get some clients who say, well, Kaefer, Stephanie, this happened in our divorce and our children witnessed everything. No problem. They're going to come to court, just tell the judge, they're going to testify, or they're going to tell him or her everything. Can that be done? Is that the way it works?
Generally, judges do not like children to be involved, whether it's, behind closed doors or in the litigation, especially in the litigation. They don't want the children to be in the middle. They don't want children to be testifying. There is a certain age range where the judge might consider a child's desire or wants, but that doesn't necessarily mean they want the children to testify.
And what is the main reason in your experience why they do not want the child or children to testify?
Because children can be unreliable. A lot of clients will come and say, oh, but my child is very mature, or, they're not, they know what they want, or they're afraid of the other party, or whatever reason they have to give to support their position that the child should testify. But
And I think, I'm sorry to interrupt, but I think
yeah,
also that a child, right, in the middle of this traumatic experience for all parties involved, many times that child would say, I want to please mom, I want to please dad. If it's a same sex couple, I want to please both dads or both moms, right? And if it's a lot of pressure on the parents in a divorce, imagine on the child.
right, correct. And then that would be another reason why the judge wouldn't want to place them in the middle of litigation either. That's a big one. They're already going through a big change. Why put the children in the middle in that way?
And I think the number one thing, we discussed it a lot in our divorce cases, is children, unfortunately, or many times, unfortunately, are the ones that don't have an advocate in the proceedings, right? Because
Correct.
mom, dad, or dad, mom have their lawyers but the court has to have the children's best interest in mind, right?
Correct,
So
right.
we want to make sure that at the end of the day, the best interests of the children are safeguarded, if you want to call it that, correct?
That's correct. There are cases, more complex custody cases, where the judge might appoint a guardian ad litem or a law guardian so that they can speak directly with the children, but that doesn't typically happen.
Understood, understood. Perfect. Next one. So this one we get from time to time, and it's either mom or dad come in and they say, Kaefer, Stephanie, if we settle in a divorce, if we come to an agreement that there will be 50-50 parenting time and custody will be joint legal custody, then there will be no child support. Is that true?
Not necessarily. Child support in New Jersey, it's a very, I would say, straightforward calculation in terms of how the courts determine a child support amount. They look at, the custody and the parenting time arrangement is a big factor. But just because there's 50-50 parenting time doesn't necessarily mean there'll be no child support. Because the other big factor is are the incomes of the parties.
Understood. Understood. And then we could have a whole episode on child support and
Yeah.
custody, but just to give some basic terminology, what I just mentioned, joint legal custody. So let's talk a
Mhm.
little bit about that. And can we keep it simple? What is legal custody and what is actually physical custody? If you could explain that.
Yeah, so legal custody is, who gets to make the major decisions in the children's lives. And that would mean medical decisions, school, not your day-to-day decisions, right? It's the ones, like I said, any medical decisions that have to be made or where they're going to go to school, those big ticket items. And typically, that's joint in New Jersey, unless there's some, major factors why a party shouldn't exercise joint legal custody. It's usually going to be joint.
Okay.
Whereas residential custody or physical custody, that's, where does the child live? With whom does the child live with?
And then I mentioned residential custody, physical custody. What does that mean?
So that's who does the child live with physically?
And then a lot of people worry about residential custody. I want residential custody. Why is it so important to focus on residential custody?
Because usually the person who has the children the majority of the time would be the person receiving child support.
And does that determine where they go to school?
Yes.
Okay. Going back to the myth, right? And you stated that child support is calculated. It's very straightforward.
Right.
It's called the New Jersey Child Support Guidelines, right? And it's a
Mm-hmm.
formula that we calculate. And the two biggest factors are income of the parties, of the parents, and basically the parenting time, the overnights of where the child is going to be with which parent, correct?
Correct.
Now, if you're going to give us an example, there is 50-50 parenting time, meaning equal parenting time,
Mm-hmm.
and there's joint legal custody. What would be one of the reasons why there would still be child support, even though there's equal parenting time?
If there's a disparity in incomes, if one person is earning more than the other parent, then it's likely the higher earner will have to pay child support.
Perfect. Okay. Okay. Now, I think this one is the next myth is one that we get a lot. It's our job as part of the legal community to educate individuals who come through our doors and also when we do seminars and things like that. But we get this a lot. Basically, a client comes into a consult and says, I will not consent to the divorce. Therefore, my significant other cannot get divorced, right? And is that true?
No. So once somebody files for a divorce, they're entitled to it, whether or not the other person agrees to that. And I usually tell if someone comes to me and they say something to that effect, I usually tell them the divorce will continue with or without you, because the court does not need your participation to proceed with the divorce. That's just a fact.
Right, right. So there's no way of declining your partner getting divorced. There's no way of telling them, well, I'm not going to sign for it, right?
Right.
They can proceed without your signature.
Yeah.
They can proceed without your participation.
Correct. Yeah.
Would you advise of that? And we'll get into that, but would you advise them not participating in their divorce?
No, no, I
We'll
would
get
not.
into that. We'll get into that. Then one of the other myths we want to tackle is, and it crosses over to real estate law,
Yeah.
right? Is a client comes in and they sit down, we go through the whole consultation, and then we ask, you and I ask, is there a marital home? And they say, yeah, we live together, but don't worry. Husband or wife, my husband or wife, are not on the deed, so they cannot touch that property. I'm safe. Don't worry. Next question. What would you say to that?
I say, well, that's an issue, right? Because it's not true. Just because a spouse is not on the deed of the property doesn't mean they're not entitled to it.
What would be a key factor in determining if they are entitled to the property or not?
Well, the court is going to look at number one, whether the home was purchased during a marriage.
Okay.
Right. So if it was purchased during a marriage, then it's likely that they have some sort of interest in it. Dealing with these type of issues can be complex because, the court will look at the length of the marriage, whether one party put more into the home than the other party. We could probably do a whole podcast just on
Right.
this issue, right?
And they're not on the deed. Let's say sometimes we have a hybrid situation where they're not on the deed, but they're on the mortgage as a
Yeah.
co-signer, things like that. Would that affect or change that position, your opinion on it?
No, I mean, just because they're not on the deed, if the spouse is not on the deed, that means that they don't have a legal interest, right? Technically, they don't have a legal interest, but they do have an equitable interest. And when we're talking about issues in the family court, the family court is a court of equity.
Playing off of this myth, another thing that we see a lot is, well, I can't buy out my husband's interest. I can't buy out my wife's interest, right?
Mhm.
So we're stuck. What would the court usually go to as a third option?
Sell the home.
And can either party say, well, I don't want to sell, but I want to get divorced? Can they stop that, or a judge can order it to be sold at home?
A judge can absolutely force a sale of the home.
Okay. And what are the pros and cons of selling a marital?
It depends on whether or not the parties have other issues going on, right?
Correct. But if I would say, for example, a pro would be it's a clean break, right? There's no
Correct.
connection anymore between them. Anyone, worried about are they going to make the mortgage payments or not, things like that. I would say a con would be, correct me if I'm wrong, a con would be if the children are going to the local high school, middle school, and they don't want to miss out on, still being friends with certain people, still doing the social activities. And because they sell the home, then maybe they have to move 20, 50 miles away because they
Right.
can't afford if
Yeah.
they sell the home, right?
Of
Can't afford
course.
living there. So I would say that would be a con, right? Like you
Of
said, it
course.
depends on the
Yeah.
case. Depends
Depends.
on the
Yeah.
case. But definitely something that we see a lot of.
Oh, yeah, absolutely.
Perfect, perfect. So Stephanie, practicing in this field for 9 years, what would be your number one tip to our viewers, to our listeners regarding a divorce? What's the number one thing that comes to mind?
Number one thing would be if you receive any court documents regarding, any type of family law issue, whether it's a divorce or, an complaint for child support or custody or, a domestic violence issue, consult with an attorney. Number one, that would be my number one advice is to always consult with an attorney.
And I would say, let me flip the question around a little bit. What would be the number one thing not to do in a divorce?
So, the number one thing I would recommend not to do in a divorce would be if you are served with a divorce complaint, don't ignore those papers.
And why shouldn't we ignore divorce papers?
So, when you're served with a divorce complaint, you have 35 days to answer it. If you don't do that in that time frame, then the court can enter default against you. And what that basically means is that they're going to move forward with the divorce without your participation. So you can, show up to the final hearing, but you won't be able to ask for anything.
Gotcha. So If you don't answer, it goes into default, and basically you're not participating in your own divorce.
Correct.
Potentially, could the other spouse ask for things and then they be granted even if they're not true?
Yeah, I mean, if they are able to prove their case and, the court believes them, the court could grant whatever it is they're requesting.
So, for example, wife or husband can say, "My spouse," instead of really they're earning 40,000, they can say, "No, I believe he or she is working two jobs, and he or she are earning 85,000."
Yeah.
And if you don't participate, the judge might consider that.
Yeah, if you don't, if especially if you're not there, if you don't appear for the default hearing, the judge only has to go off on what your spouse told them. So,
In your experience, what would you say is the craziest or ridiculous issue that you've litigated in a divorce? Something that really stands out in your 9 years of practice.
yeah, I mean, one thing that I've come across a few times have been, what happens to pets, right?
Okay. Okay.
Dogs, I guess specifically.
Cats too. Don't forget about
Yeah,
cats.
cats
Yeah.
and dogs.
Yeah.
But I guess personally, I've seen a lot more issues with the dogs
No
than the
one wants the
cats.
cats.
Sorry for anybody who's, a cat person, but
Gotcha. Gotcha.
it's the dogs, their family. So people get very emotional, especially if they got a dog while they were married and there's children involved. I've had cases where a dog was gifted to them by the other party. What happens? Technically, dogs are considered property, but that's not how most people see their
Of
pets.
course, of course. There's a lot of emotional
Yeah.
attachment, memories, things like that. But what do you do in that circumstance? I mean, it's a family dog,
Right.
I guess. There's children involved attached to the dog too. How do you determine if there's only one dog,
Yeah.
how to break up that dog between the parties?
Luckily, I would say all of the cases that I had where, the dog issue comes up, they were able to settle that in an amicable manner. I've had people share custody of a dog where the dog will spend 1 week with one party and then the next with the other, and they keep going. Or I've had, some people also basically they would be on the same custody schedule if children are involved. The dog would go with the children. I've had that before. Or, one person just, waives their right to the dog, which, is sad.
I also wanted to delve into, if you want to call it a misconception, right? We see on our phones, on social media, on TMZ, if you want to refer to that, of divorces, how they're
Mhm.
portrayed in the media, how we see them in TV shows. What would be the biggest misconception of that image?
I think that, TV shows and, what you see in TMZ, they set unrealistic expectations.
Okay.
Which is why I say you have to consult with an attorney so they can kind of tell you what your rights are. Some of these TV shows, they show things happening very fast.
Right,
That's not
right,
the way that it
right,
works in
right.
real life,
That's
right?
true. That is true.
For example, trials. The number of cases that actually go to trial in the state of New Jersey, it's a very low number.
Right.
And even before you get to a trial, a lot of things happen before then.
Of course.
A lot of people will come and they think they can just automatically be seen before a judge and just, go into all the issues that have to be resolved, but that's not the case.
Right. And also highlighting, we get a lot of clients who say, well, my cousin, my uncle, my aunt, my brother and sister, they got divorced in, let's say, just for argument's sake, Bergen County.
Yeah.
And their divorce happened really quickly and it went this way, this way, and this way. And then they're coming to our office saying, well, I live in, let's say, Passaic County.
Hmm.
Is there uniformity in how things operate, how things move in a divorce, how things are handled statewide, or is it different from county to county?
It can be different. Procedurally, things are, I would say, uniform, right? The type of documents we have to file, certain programs in the courts. But even so, every county is different. Each county has their own way of doing things. Even within the counties, different judges might perceive cases differently and decide similar cases different. So, I always say you can't really go by what your friends tell you or your family, because their experiences are going to be different than yours.
No, definitely. We see it all the time, right? Even the same county, different
Hmm.
judges rule differently. And
Yeah.
I think that's the one of the hardest things about family law and divorces is that not every divorce, like we stated before, is the same.
Yeah.
Every divorce has different facts, but also every divorce is perceived differently by
Mhm.
different judges
Right.
and processes in courts. So definitely something that we want to highlight for our viewers.
Yeah.
Another thing, Stephanie, wanted to ask you is, when a client say, "Do I need an attorney? Is it necessary?" And if I get an attorney, we also hear, "Oh, I'm afraid my partner, my significant other, is going to see it as a threat, as
Mhm.
something being escalated. I
Yeah.
don't want to take it there. Do I need an attorney?"
Yeah, I think that everyone should first consult with an attorney, right? But I do think it is necessary to have an attorney to represent you, because at the end of the day, you and your spouse could be getting along, but that doesn't necessarily mean that you know yourself what rights you have and whether or not you're protecting your own rights.
So, for example, let's say a husband and wife solidified a child support amount. They solidified legal custody and physical custody. They solidified the pet situation. And then they say, look, I really don't need an attorney. That's all we have,
Yeah.
right? What's one thing, just throw out an example, one thing that maybe they could have missed that later on could have severe repercussions?
So I think a number one thing that people don't realize or they think it's a resolved issue are accounts in their own names or retirement assets, in marital debt, right? Or just debt in general, right? It's in somebody else's name. A lot of times people will come to us and say, oh, well, this is in my name only, so I didn't think that was an issue. But it is. Everything that's accumulated while you're married, that goes into the pot, as I say. So whether it's, a credit card in your own name that you said maybe I don't want the other person to pay, so it's not an issue, it could still be an issue and it should still be addressed.
No, definitely. We see all kinds of debt, right? Personal loans, IRS tax debt,
Yeah.
medical
Mhm.
bills. We've had, correct me if I'm wrong, husband or wife takes the other person's Macy's card and goes on a shopping binge
Right.
monthly,
Yeah.
right? So those are things that needed to be dealt with.
Hmm.
Dealt with. Now, another thing is we even forget some issues, for example, that are newer issues now. I know I've had a consult recently where the husband came to consult with us and they really don't have a lot of assets, but the wife wants compensation or reimbursement for the chest enhancement she had, right?
Right.
And the husband said, "Well, it's not for me." And literally, he tells me that she responded, "Well, you enjoyed it."
Yeah.
So those are things that us attorneys have to deal with,
Yeah.
right? Who paid for it? Uh, what is the resolution in this matter, right? So
Right.
I agree, a lot of people forget about that debt in a
Hmm.
marriage.
Yeah.
So, Stephanie, for our viewers listening and watching, one thing I wanted to ask you, not necessarily just why they should choose Garcia Law, but why
Mhm.
should they choose Stephanie O'Neill as their divorce attorney? Because as we both know, and people who've gone through divorces personally know, it's probably one of the toughest chapters in someone's life that they have to learn how to navigate through with the help, of course, of experts, right? But
Right.
why should that expert be you?
Yeah, I've been doing this for 9 years now. So I have a pretty good grasp of what I'm doing. I've seen a lot of different issues come my way, a lot of different cases. So, I can confidently say that I can, handle anything that comes my way. The other strength that I have is that I'm a court certified mediator. So what that means is when two people are going through a divorce, at some point they might have to go to economic mediation, and the court is going to give them a roster of different mediators that they can choose from. So, what that means for my clients is that I'm able to see both sides. I can anticipate what the other side might argue against some of the positions we have. So, the bottom line is I'm here to help people. That's what I said in the beginning is that I came into this wanting to help people get through one of the most difficult times of their lives. And I know that I can confidently do that.
I think a lot of what we talked today is just a glimpse into the complexity of a divorce
Yeah.
because every divorce is different. I think you would agree with that.
Yeah, absolutely.
And we have a lot of clients who come in and say, I've talked to my significant other, we reached an agreement, and we reached an agreement that child support will be X and we'll have joint legal custody and residential custody with X person. But then we start asking questions, right? What about the
Yeah.
retirement accounts? What about marital debt? What about properties here or in another country? What about the dog? What about the cat? All these things that people forget and we have to deal with
Yeah.
in a divorce. Because tell me something, if we do not deal with it, if it's not on paper written down that this is going to happen to X, if we leave it out, what would be the consequence of that?
Well, one thing could be that you waived your right to it. You can't come back to court and, reopen that issue, which is, I think a lot of people don't really think about all the issues that need to be brought up. And, if another tip that I would give, people who are listening, who are going through a divorce or, any type of family law case is to tell your attorney everything that's going on. Whether you might be insignificant, but your attorney would be able to give you advice on it and let you know whether or not it's something that should be addressed. You don't want things to not be addressed and then you can't come back to court, or you come back to court after the divorce is over, just for a judge to tell you we can't open up that issue.
Of course, and our viewers and people who come in and in and out of our office, the one thing we want to make sure is they're informed, right?
Correct. Yeah.
Because if you waive your right to something, if you forget something, if you don't mention something in your divorce, the consequence of spending more money to fix it later on, the consequence of time being wasted, the consequence of maybe having a permanent consequence and not waiving your right to it is enormous. It has repercussions, it has a ripple effect, not for you and the other person, but also for the children, for the whole family. So it's something that here at Garcia Law we focus on a lot, right? Our job is to inform and make sure that we guide people in the right direction. So, Stephanie, I want to thank you for being on the episode today. I'm sure we'll have you back. I have a bunch of topics we have to cover in the future episodes, right? Stay
Yeah.
tuned. We're going to address things like prenuptial agreements, postnuptial agreements, issues with pets, child support, custody. So, definitely give us a follow. We'll have Stephanie back on separate episodes to address all these issues that we can spend
Yeah.
hours discussing. So, Stephanie, I want to thank you for joining us today, and it was a pleasure having you.
Thank you.